A very good morning to Madam Maizatul. Today, my group from Tutorial 8, Group 1, will be presenting our cases for ITL. My name is Nur Inshira binti Muhammad. I am the group leader, and my other members, Yvonne Ling, Aina Elisa, Danyata Devi, and Tanushri. I'll be moving on to the content. So we have two cases, one from Section 3 and one from Section 5. So the Section 3 case will be CAS v MPPL and another 2022 12 MLJ 135. And the Section 5 case is PT Karya Sumiden Indonesia and Ocean Masters Marine Services, Sendirian Berhad and another 2016 7 MLJ 589. So I'll be explaining on the first part of Section 3 case. So for the brief facts of the case, the parties involved include the plaintiff, who is a Malaysian airline pilot claiming to be the biological father of the child. And the first defendant, or D1, is a stewardess who is married to the second defendant. However, she was also on the same Malaysian airline as the plaintiff. And the second defendant, who is a Singaporean airline pilot and the husband of the first defendant. So for the key events is that D1 and D2 got married in 2007 and had a baby girl born on 2008. However, the plaintiff and the first defendant also had a secret relationship that was quite sexual from 2005 onwards. So this is why the plaintiff claimed that he was the biological father of the child and that he and the first defendant had continued their sexual relationship throughout the period of the child's conception. So the plaintiff also provided financial support and he was very much involved in the child's life. However, this ended in January 2014, where D1 ended the relationship because she found out about the plaintiff's extramarital affairs. So in November 2015, the plaintiff filed a court order for a DNA test to be conducted in order to determine the paternity of the child. And this was denied by the first defendant because she said she spent all her time with only the second defendant during the period when she gave birth to the child. On the issue of facts related to the common law and equity in Malaysia, it would be that whether the court has the authority under Section 3, Sub 1 of the Civil Law Act 1956, or known as the CLA 1956, to order a DNA test to determine the child's paternity. If they do have the inherent jurisdiction or the authority, should this order be made, and to what extent is the court's inherent jurisdiction under the parents patriae? And is this power limited to statutory provisions and or the Civil Law Act 1956, specifically Section 3, Sub 1, in which whether the law is compatible with the local circumstances of Malaysia? Decision of this issue by the court, in which the court does have the inherent jurisdiction under parents patriae to order a DNA test. This is due to the multiple evidences submitted by the plaintiff, and which the plaintiff established a prima facie case suggesting that he may be the biological father of the child because he proved that, for one, he had a sexual relationship with D1 throughout the time that when she conceived and when she gave birth. Two, plaintiff provided financial support for the child. And three, he was very involved with the child's life from the moment the child was born until the moment this case was established. So according to Section 112 of the Evidence Act, it does not bar inquiries into paternity when it's supported by evidence, which the plaintiff had already given. And they also showed that the court clarified that the legitimacy and paternity are two distinct legal concepts, and taking into account the best interest for the child, the child has the right to know her biological father, and this outweighs the statutory presumptions of legitimacy. So if this DNA test is to be carried out, and that the plaintiff really gets to know whether he is the actual father of the child, then certain lengths will be taken in order to reinstate his position as the biological father into the child's life. And this will be done under professional guidance.
For the ratio decidendi, there are three main factors towards it. The first factor is the inherent jurisdiction and the parents patriae. The parents patriae allows courts to act in children's best interest where statutory provisions are silent. And this principle is derived from the English common law, which remains applicable in Malaysia under the Section 3, Subsection 1 of Civil Law Act 1956 if it is consistent with local circumstances. The next factor is the statutory presumptions versus paternity inquiries. Section 112 of the Evidence Act establishes a presumption of legitimacy, but it doesn't preclude any investigations onto the biological paternity. Furthermore, the court held that inquiries are permissible when it's supported with evidence that aligns with the child's welfare. Lastly is the best interest of the child, where the court prioritizes the child's right to know their biological origins, and the DNA test also provides a 99.96% accuracy, which makes it a reliable method in determining paternity. Next is the stare decisis. In the case of Lim Hui Tik versus Li Lai Cheng, it established that legitimacy and paternity are two distinct concepts, and the case was pivotal in clarifying the scope of judicial power under the parents patriae principle. Next, in the case of Stonewall, Berhad and Ingare, the Malaysian Court of Appeal highlighted the court's inherent jurisdiction to act in areas where statutory provisions are silent. For the case of Babu Remlayang Vitil versus Vidya, daughter of Santini Kalatin Palidatil Vitil, Section 112 of the Evidence Act addressed the child being born into a recognized marriage or not. This serves as proof of the child's legitimacy from a genuine marriage, which can only be refuted with evidence of the couples not being together. And lastly is the case of REL and BR versus BBJ, which upheld the inherent power of courts to order any DNA tests for paternity disputes for the child's best interests. Lastly is the overall judgment. The court ordered the defendants to conduct a DNA test at Hospital Tunku Azizah, where the hospital responsible for collecting the DNA samples through any appropriate methods in order to determine if the plaintiff is the biological father or not. Should the paternity be confirmed, the court must issue a formal declaration of the plaintiff as the biological father. A child psychologist must be appointed within 21 days to help reintroduce the plaintiff into the child's life, and the plaintiff has liberty on potential future orders for the maintenance and access towards the child. Lastly, the court made no orders regarding costs. Now I will be passing on to my roommate to discuss about Section 5.
So I would like to continue Section 5 case, which is PT Karya Sumida Indonesia and Ocean Masters Marine Services Sdn Bhd and another. In this case, the plaintiff, Karya Sumida Indonesia, entered into a contract for the shipment of goods with the defendants, Ocean Masters Marine Services Sdn Bhd and Sapphire Line. However, KSI faced issue with the shipment process like contract and sales terms, shipment process, failure of payment and use, the use of switch bills of lading, and also the cargo delivery. These issues lead to a legal dispute regarding KSI's rights over the goods. The first legal issue of this case is, does KSI have local standing to bring this action? The decision is related to Section 5 of Civil Law Act as it incorporates the Bills of Lading Act 1855 into Malaysian law. The court concluded that KSI did have local standing to bring the action against the defendants. It was established that the rights of the carrier or to claim freight was preserved under Section 5 of the Civil Law Act and Section 2 of the Bills of Lading Act 1855. The court ruled that since KSI retained control over the goods through the Bills of Lading, it had the right to claim against the carrier for breach to contract. The court held that under the Bills of Lading Act 1855, KSI's rights to claim was preserved, even though the goods were shipped under a bill of lading. The documents against payment arrangement ensure that KSI maintained control over the goods. The court emphasized that the property in goods did not pass to J&M until full payment was made, highlighting the importance of the documents against payment arrangement. This case aligns with the decision in Samsung Corporation and Devon Industries Sdn Bhd 1996, where the Singapore High Court ruled that property and risk pass to the buyer upon shipment under a FOB contract. However, KSI's case was distinct because the documents against payment preserved KSI's title to the goods, making the case significant in interpreting the Bills of Lading Act 1855. In conclusion, the court decision affirmed that KSI retained rights to the goods despite the failure of payment by J&M. This case highlights the importance of bills of lading in international trade and the protection of a shipper's rights under the Bills of Lading Act 1855, especially in the context of documents against payment arrangement. I would like to invite Tanushree to explain the second issue.
The second key issue of PT Karya Sumida Indonesia versus Ocean Masters Marine Services Sdn Bhd and another is KSI's action time-bound under Article 3, Rule 6 of the Hague Rules of the Terms of Sapphire House Bill of Lading. The decision of this issue is the court upheld the principle that cargo should only be delivered against the presentation of the original Bill of Lading. Moreover, the court cited previous cases affirming that delivery without presentation of the original bill constitutes misdelivery. And Ocean Masters was found in breach of contract for releasing the cargo to JMMS customer Alfanar against switch bills of lading without ensuring the original bills were surrendered. The Ocean Masters failed to verify if the proper procedures had been followed, leading to its liability. The Sapphire was also found liable for breach of its duties as the issuing agent of the House Bill of Lading. Despite acting under instructions from Ocean Masters, Sapphire was responsible for ensuring the proper release of goods against the original bills of lading, and its failure to do so led to its liability. The court determined that PT Karya's action was not time-barred under the Hague Rules, and it concluded that the Hague Rules time bar applies only to the carrier's liability before discharge and not to misdelivery occurring after discharge. So the court found the liability for misdelivery was separate from the scope of Hague Rules. Next part is about ratio decidendi. The court reaffirmed the principle that cargo should only be delivered against the presentation of the original bill of lading. Ocean Masters and Sapphire were both liable for misdelivery, and the Ocean Masters was in breach by releasing the cargo against switch bills of lading without ensuring the surrender of the original bills, and Sapphire was liable as the agent responsible for issuing the house bills of lading and ensuring proper delivery procedures. Both defendants failed to adhere to the legal principle protecting cargo owners' rights to the goods until proper documentation was presented. The time bar under Article 3, Rule 6 of the Hague Rules does not apply to cases of misdelivery after discharge of goods. The court interpreted the Hague Rules as limiting the carrier's liability to the period before discharge and found that misdelivery claims are separate from the discharge process. Therefore, the PT carrier's claim was not time-barred as the relevant time period began from the date of delivery to Al-Fanar, not from the date of arrival at the loading port. The stare decisis of this case is about in examining the liability for misdelivery. The court referred to the Peninsula and Oriental Steam Navigation Company Limited versus Rambler Cycle Company Limited, 1964, 30 MLG 443 case, which clarified that the Hague Rules do not apply after the discharge of goods. So this case, as well as more recent decisions from Hong Kong and Australia, provided persuasive authority in ruling that the time bar under the Hague Rules does not apply to the misdelivery claims that arise after the discharge of the goods. The principle of stare decisis ensures that the decision in this case will be binding in future cases with some similar issues regarding the time bar provisions in maritime law and the application of the Hague Rules. Finally, courts would generally follow this precedent when dealing with time-limited claims under a bill of lading, reinforcing the rule that parties must bring their claims within the time frame stipulated in the Hague Rules. Now I would like to pass to my partner regarding this case.
Thank you to Tanushree. Now I would like to talk about issue 3 is whether Ocean Masters and Sapphira are in breach of contract as courier or in breach of duty as bailee for reward in releasing or allowing the cargo to be released without due production of the original Sapphira house bills of lading. Now, the decision of this issue is whether the court emphasized the importance of certainty in commercial contracts while ensuring justice and fairness in contract enforcement. The court upheld the principle that goods must only be delivered against the original bill of lading. The rule safeguards predictability and trust in international trade. It ruled that established principles of certainty, particularly regarding the strict requirement for delivery against the original bill of lading, must be upheld to maintain trust and reliability in international trade. Now, according to the Hague Rule, the court decided that the time bar under Article 3, Rule 6 of the Hague Rule did not apply to misdelivery claims because the courier's responsibility ceased after the discharge of goods, and misdelivery claims therefore fall outside of the scope of this time limitation. The court applied equitable principles to prevent injustice arising from technicalities like unclear delivery dates. Moving on next to the ratio decidendi of this case, where certainty in contracts, the principle that delivery should only occur against the presentation of the original bill of lading was upheld to ensure consistency and reliability in trade practices. The certainty is vital for protecting cargo owners' rights and maintaining the integrity of commercial shipping. Moving on next to the application of the Hague Rules, the time bar under Article 3, Rule 6 of the Hague Rules applies only to liabilities arising before discharge and does not cover claims for misdelivery that occur after discharge. And this is also because of the misdelivery after discharge claims are separate from the discharge process, ensuring PT Karya's claim was not time-barred. And also, the last one for ratio decidendi is the equity in justice. Equitable principles were invoked to ensure fairness, particularly in cases where rigid adherence to technicalities could result in unjust outcome. The stare decisis of this case is delivery against original bills of ladings, where the court reaffirmed precedents such as Si Hai Tong Bank Limited against Rambler Cycle Co. Limited, 1959, which established the necessity of presenting the original bill of lading for delivery to occur. Misdelivery after discharge, the court relied on Peninsula and Oriental Steam Navigation Co. Limited against Rambler Cycle Co. Limited, which clarified the Hague Rules time bar does not apply to misdelivery claims occurring after discharge. And agency and switch bills, the decision followed principle from the Feng Hang confirming the issuing switch bills of lading in violation of the original contract of carriage constitute a breach of contract supporting PT Karya's claim. Now, moving on to the overall judgment of this case of Section 5, PT Karya was awarded damages for the loss of the cargo, which was valued at USD 5,914 and 10.40 cents, along with interest and legal costs. PT Karya is also entitled to the cost of this action from Ocean Masters in the sum of RM 80,000 only. Now, I would like to pass this to Inshira to conclude.
So I would like to thank all my teammates who have already presented their work. In conclusion, I would like to say that doing this assignment really helped us to expand our knowledge in terms of reading case laws and so on and so forth. That is all from us, Tutorial 8 Group 1.